Sorry.
Can you get out?
You're supposed to be out of here.
No, I was not. Can you get out? Can you hurry up? I am naked.
That's fine.
What the hell?
You're supposed to be out of here.
Fix things or just maybe wrong.
They didn't fix anything. They didn't come in here to fix anything.
Or doing whatever they can change the filter, whatever they came here to do. Now, insane. There's nothing we can do about that at the moment or anything like that.
So did they tell you why they came into my home?
Nope.
So they can just walk into my home while I'm naked, just without notice.
They're saying they knocked and announced.
But there needs to be a notice. There has to be a notice in order for them to
I will
enter my home.
contact your management and talk to them about that.
Contact management. So two strangers can enter my home. Whether they say they're maintenance or not, they enter my home while I was naked. While I was naked. Okay.
I think what he's saying is the circumstances are not okay. I don't think we're saying that what happened is okay. Like, of course, if you yelled, "Hey, I'm naked," and they heard
and they said no,
kept coming in.
I said, "Can you get out?" I stood right here.
I can tell you right now, I am not going to arrest a maintenance worker.
You're not going to arrest a maintenance worker for walking into my home without a 24-hour, 48-hour notice or anything. It is illegal for them to enter my home, whether they own the apartments here or anything. The maintenance workers see me as naked.
Where have you read that somewhere?
Yes. Yes.
Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
She was just getting ready for work, perhaps in her bedroom or bathroom, when she heard unexpected footsteps in her living room. Heart pounding. She steps out, freezes. There is a man standing there, inside her apartment. He casually says he is from maintenance. But she never called for any repairs. She never received any notice from the landlord or management that anyone was coming. There was no email, no note on the door, no phone call, nothing. Terrified and half-dressed, she immediately calls the police. When officers arrive, they speak to the maintenance worker and then tell her they will not charge him for entering without permission. They also say he never explained why he was there. Shaken and feeling violated in her own home, the woman now poses the following question. Was this an invasion of privacy? Should the maintenance worker, or should the landlord, face charges? Why did the police refuse to act? And what laws were actually broken here? Today on Team Tiggio Court TV, we break down this disturbing real-life scenario based on tenant reports and similar viral stories, the key laws involved, why police often will not pursue criminal charges in these cases, whether the tenant has a strong claim for invasion of privacy, especially since she was not decently dressed, past cases where maintenance workers did face charges for unauthorized entry, and what options she really has. If you have ever worried about who has access to your home, this one's eye-opening. First, the core issue. Unauthorized entry by maintenance and landlord agents. In most U.S. states, landlords and their employees, like maintenance workers, have a limited right to enter a rental unit. It is not unlimited. Tenants have a right to privacy and quiet enjoyment of their home. Entry without proper notice is generally a civil violation, breach of lease, trespass, not automatically criminal, unless there is intent to commit a crime, theft, assault, or voyeurism, among other crimes. Key laws typically broken or at least violated. Trespass or criminal trespass varies by state. Entering without permission or lawful authority. Many states classify unauthorized apartment entry as criminal trespass if the person knows or should know they are not welcome. Therefore, if there is no emergency, there should be a notice. But prosecutors often decline to charge if it is just maintenance and no damage or theft occurred, viewing it as a civil landlord-to-tenant dispute. Invasion of privacy civil tort. Intrusion upon seclusion, one of the 4 privacy torts. If the entry was highly offensive to a reasonable person, especially catching someone undressed and preparing for work, and there was no consent notice, The tenant can sue for emotional distress, humiliation. Courts recognize that surprise entry into a private home, particularly when the tenant is in a state of undress, can be actionable. Breach of lease and landlord-tenant statutes. Most states require reasonable notice, often 24 to 48 hours, for non-emergency entries, repairs, inspections. No notice equals violation. Some states, such as California, New York, and Florida, mandate written notice, while other states imply it via quiet enjoyment covenants. No work order or reported issue strengthens her claim. No legitimate reason existed. There is no criminal invasion of privacy statute in most states for that purpose alone. T is usually civil unless tied to peeping, recording, or harassment. Why did police say they will not charge the maintenance man? Police often treat unauthorized maintenance entry as a civil matter, landlord-to-tenant dispute, unless there is clear criminal intent, such as burglary, assault, or theft. If the worker claims, "I thought I was supposed to be here," or routine check, and there is no other crime, defense attorneys rarely prosecute, making cases like hers low priority and hard to prove intent beyond a reasonable doubt. Lack of notice or a work order is a lease violation, but not criminal trespass if the worker had a master key authorized by the landlord. Police defer to civil court for eviction remedies, damages, or injunctions. If she was not decently dressed, that adds emotional distress, but does not automatically make it criminal, unless the entry was for voyeuristic purposes, rarely provable without more evidence. Should the maintenance worker or landlord be charged with invasion of privacy or trespass? Criminal charges. Unlikely without more actions, like a pattern of entries, theft, or harm. Police refusal is common in non-emergency unauthorized entries. Focus on civil remedies. Civil claims. Stronger case. She could sue for invasion of privacy and intrusion upon seclusion. Especially humiliating, she was undressed, preparing for work, trespass. She could also claim intentional infliction of emotional distress. The claim could also include a breach of quiet enjoyment and lease agreements. Potential damages. Compensation for distress, nominal damages, possibly punitive if reckless. Maintenance workers have been charged in the past, showing that it is possible when there are aggravating factors. Providence, Rhode Island, 2026. A maintenance worker entered the unit, went through clothes, and masturbated, charged with breaking and entering and related offenses after the tenant presented video evidence. Or in El Paso, Texas, 2021. A maintenance man unlawfully entered an apartment and attacked and strangled a woman. The former worker was charged with felony assault and burglary. Another entry happened in Berks County, Pennsylvania, 2022. A worker used a master key to enter a woman's apartment and peep, charged with invasion of privacy. Peeping in upstate New York, 2025. A worker made a sexual advance after unauthorized entry and was charged with aggravated sexual abuse. These cases involved additional crimes, sexual misconduct, violence, and peeping, turning civil trespass into criminal. Cure no notice entries usually do not lead to charges unless repeated or harmful. What should she do next? Document everything: photos, timeline, police report number, and any communications. Send a written demand to the landlord or management, explanation, apology, and assurance of no future unannounced entries. File a civil suit in small claims, low costs for damages if distress is significant. Complain to the housing authority or local tenant rights organization for lease violations. If a pattern emerges, seek a restraining order or lease termination. This story highlights a huge tenant fear: unexpected strangers in your home, especially when vulnerable. No notice means no chance to prepare or consent, pure violation of privacy. What do you think? Should police charge in cases like this, even without extra crimes? Is no notice enough for criminal trespass, or should it stay civil? Have you had unannounced maintenance entries? Drop your thoughts in the comments below. If this breakdown got you fired up about tenant rights, hit like and subscribe to Team Tiggio Court TV for more real-life breakdowns, privacy violations, unauthorized entries, and legal what-ifs. Turn on notifications. We cover cases that matter. Thanks for watching. Stay safe in your home. See you in the next one. See you in the next one. See you in the next one.